Hello. What do you do if a provider you have, medical and or mental versus physical provider, that could be a therapist, a psychiatrist, or on the physical side, it could be a doctor or a physician assistant or whatever. I have to say that I have not seen that, generally speaking, of late with physical medical providers. However, I don't think it's that uncommon with mental health providers. And it's nuts. So had a question, person's asking about what to do. Like the provider sounds like she's gonna dump her client patient because she doesn't want to get involved in his claim. Because what happened was apparently the SSA did what they are supposed to do and sent the authorization, that's the SSA 827, that the claimant executed when he first filed. And that is a HIPAA request for medical records to be sent to the SSA. And for some reason, this therapist apparently is got her short hairs in a bunch and thinks that that means if she sends a record, she's getting involved in his claim, which it isn't. It's actually mean you're complying with HIPAA access rules. And if you don't, you could have a complaint filed against you with the Office of Civil Rights. Aside from the fact that it's just a total backstab to your patient client, not allowing the records to go out. Now, I think there is a different video where we talk about the fact that mental health records do have a little caveat when it comes to HIPAA access. Yes, they have to provide the records, period, end of story, no different than physical doctors and offices must. However, they are allowed to exclude from what they share something called psychotherapy records. Psychotherapy records are not the results of the mental status exam. They're not the result of the observations of the person, their affect, their demeanor, their thought processes, anything like that. How long the session was, what the prescriptions are, that's all in the medical record that must be revealed. The only thing they can hold back is something called psychotherapy records or notes. And it's actually defined at I think it's the HHS site, Health and Human Services, to help them understand that this is the narrow carve out you have. No, you don't have, you're not the king or the queen that can deny a patient his records. It's ludicrous. I have seen, nonetheless, though, providers, even a local big company provider, and when it's a big company provider for mental health, it's usually a Medicaid receiving entity, and it's very important we have them, but they really need to get up to speed. I know they're probably overworked and underpaid. That's a problem. But I've had direct conversations with, a receptionist who answered the phone after I called, which I don't typically do because it's pointless. I prefer everything in writing. And she said, "Oh no, we're not allowed to send out our patients' medical records despite their HIPAA request." And I wanted to be like, "Listen, little girl." You know what I mean? Like, you don't know squat. You're answering the phone, Here, let me send you the HIPAA rule. Okay. I mean, it's in print, it's in the federal, you know. So, and that entity had a lot of people living under bridges. And I think it was because they were not giving up records that would help these people win their SSI case or their SSDI case, depending on, where they are at in their struggles and financial wherewithal after probably years of not being able to get these records. So to me, it's criminal. And I would suggest, like, if the way it was described to me, that this therapist was so affronted by the thought of sending out medical records for her patient. And I know they like to call them clients, right? Because they're not doctors. That's fine. Client, patient, whatever. I mean, if she was a psychiatrist, it would be a patient, right? So not only is she not apparently going to do it unless she gets a little bit of information that might convince her otherwise, she wants to drop the client because this is just an insult. What are you talking about? I mean, it's not about you. So if you have a provider like that, And again, I don't really see this in the physical world. They're a little bit more on top of HIPAA and stuff. I mean, while most people seem to think HIPAA is only about your privacy, it's also about your right to access. And that is a huge, huge important factor. It's huge when you're doing a Social Security disability or SSI case. It's huge probably when you're doing an LTD case, if you happen to have, the good fortune of having a long-term disability policy through work or that you privately bought. So if it was me and I had a provider who, first of all, treated me that shabby, I think I just did a video on someone else's situation where their provider is just outright rude all the time. But in this case, and I think there was a records request too, maybe that's where it came up. But in this case, yeah, I definitely get another provider, another therapist. Try to play nice until you do so. And yeah, we're still going to want to push for those records. Now, I'm not involved in this person's case. They were just asking me some, my perspective. So one thing you can do, and if you have a lawyer or a non-attorney rep, they can do this too. Request, if you're at the judge level, the ALJ level, request that the judge subpoena those records from that provider. It might give her a wake-up call. It might have her realize that she doesn't know squat, and she's trying to be a little Miss Lawyer therapist when she should probably just stick to therapy. But that is one thing, and it's not always that effective. So, but it sometimes it is. You can also send some literature that will let her know what the repercussions are for violating HIPAA in terms of the access. Now, I will say HIPAA doesn't have the bite I wish it did. It's pretty wimpy and disappointing. But, for like 99% of the violators nothing happens to them. But, she might be the one that it does, because if she does this enough to enough people and they send in, and by the way, the form to do it, which can be emailed to the OCR, takes like 2 minutes. It's really short. It's nothing complicated. So getting another therapist, maybe getting a judge to subpoena those records on your behalf, educating the ignorant provider who doesn't know the laws that surround her field. Can you tell I'm a little ticked? And it's not my client, but it shouldn't happen to anybody. So there might be, I've heard other people suggest this. What about contacting the psychiatric or mental health therapy licensing board of the state and saying, this is what's going on? I'm sure someone's not going to appreciate getting called out like that. But honestly, it's for her own good, because if she continues to do this, she is going to have a HIPAA violation. And I don't know, I know it can be very expensive. The fines, they sanction them. So it's all about, federal government making some bucks probably. But occasionally that is what makes bigger providers who have to look at the bottom line, maybe they're corporate providers, that makes them buck up and get really serious with their employees who might do this. But for a standalone person, they don't have that legal department looking over their shoulder, and they can make mistakes. This one to me just seemed like not a nice person kind of mistake. It wasn't like she was saying, oh, what's this about? And just slow. It was, I'm not getting involved in your claim. No, you are involved, woman. You know what I mean? Like, you are involved. You are the provider. You're a licensed provider. And this is one of the rules you live by in this country. You have to provide the records when requested. So the other concern, of course, is that, well, you could push her to it, but will she start adding like things into old records to make them look bad? That would be psychotic. Could it happen? Sure. I'm sure there's a lot of psychotic mental health providers. They're all sprinkled throughout life. There's lawyers that are psychotic and everybody else. But you just gotta do something. You're gonna need those records. But in the meantime, play nice and get another therapist. And then when you cut bait, hopefully by then you will have had the records. I mean, little nice pamphlets put out by HIPAA advocacy groups that explain, yeah, this is what you got to do, or else you run the risk of blah, blah, blah. You could do that. I know I have some narrative, and I do with my clients. I will send it after 2 or 3 ignored requests. Sometimes it's do you know you're past the 30-day mark? you're in violation of HIPAA. Sometimes it's like you violated the fee limitations of HIPAA. HIPAA violation. Yeah, because sometimes they'll try to for the entities that have a state law that allows them to charge an arm and a leg, like New Jersey was like this. Gotta love that Jersey. They would say, Jersey says I could charge $500 or whatever. And I'm exaggerating there. It wasn't $500. And so we'd send back the thing, no, federal law trumps your New Jersey law. And federal law says when this kind of HIPAA request is made, and it's a very specific HIPAA request in terms of keeping that price down. Spam. You know, do as you will, but I happen to love sending up OCR complaints. It's so easy. But I do leave it up to my clients. I will help them put it together if they need it. But they will send it from their fax, and it's from them, not from me. Simply because, there is even language in the directions that says, if you're not the person and the person's anonymous, we might have a hard time asking that person quite. Of course they would. So you do kind of want to, I think, maybe identify yourself as the victim so that they can, find out specific things. Oftentimes, I mean, this is where I can kind of come in. I have copies of all the patient's requests that went out that the patient ordered records from. Now, granted, they might have been faxed by Staples or by grandma or by us, because logistically they get help. But the request is specifically from them to the provider, directing the provider to send the records electronically back to the patient. There's no third party involved. And yeah, I mean, I actually have a video on that. If you want to look at it, look under the playlist. I think it's called HIPAA. But they have to comply with this, or else they are violating HIPAA. HIPAA is a little undertoothed, but it's still something. So I would do that. And I've always been throwing out the question out there, isn't there any lawyers out there, like young lawyers who are trying to make a niche, maybe a cottage industry of going after providers who refuse to send their records to the patients when the patients provide a valid HIPAA? I don't know that there is. I wish there was. I mean, I'm not going to run with it because I've got a business that I 24/7, but I would be willing to help if someone wanted to do that and put my input in. And then I would give them all my business too. All of my, because they say HIPAA, the OCR does not represent individual people. So, you're kind of on your own, but if we see enough bad acts from, usually it's a big company, not the little guy, we might sanction them. Okay, that's great. And I think sometimes they just notify the person that, there's been a complaint against you, and we're going to review it. And then the person bucks up and sends the records. But as for a person against a provider legal action, I don't know that one has been nailed down, although it seems to me it would be a breach of contract. When I go to the doctor's office, there's usually that bill of patient rights, and they might all be subject to it, whether it's posted or not. And I suspect one of them is that you have the right to a copy of your records. So if that was our agreement, and now I've paid you and my insurance company has paid you X dollars, and now you're not completing what you owe me, I consider that breach of contract. You don't want to go the medical malpractice way, even though it could very well be that as well, because those laws definitely require some pretty hefty business going on. So that's a little bit of an overkill. But what about a breach of contract? I agreed I was going to let you examine me, treat me. You agreed to respecting my patient bill of rights. It's just something to look into. I know I'm not going to have time to do it, but if I were a brand new lawyer or been out for a few years, I'm an old dog, but if I was, and I was trying to develop some interesting niche that nobody else is in, and boy, then you don't even have competition. That's something I'd be looking at. Anyway, hint for all you new lawyers. Okay, guys, I'll talk to you later. But bad providers, particularly those solos, you do have a little bit of recourse. It's not perfect though, obviously. I'll talk to you later. Bye.